Jermaine Bay with a loading Morris Pradium ante Colorado. The acronym is AMPAC. I'm the Chief Judge of Consular Court. Today is Class 47, Class 47. What did we learn in Class 46? Well, we started really looking at the correlations, right? We were looking at what's called discernment. We were looking at forensics, of taking a look at what's called the 1906 Capitulation document of the House of Representatives of the United States of America. And in that year of 1906, they were trying to determine whether they wanted to sign the Act of Algeciras of 1906, right? So therefore, they were looking at all the previous Moroccan treaties. They were looking at 1787 and 1836. More specifically, they were looking at the Treaty of Madrid of 1880 before they decided to sign the Act of Algeciras of 1906. They recognized by signing the Act of Algeciras of 1906, it had some very favorable language in it that protected them, but at the same time, it gave a lot of specific language that helped protect the Moors' sovereign rights. And one of the things that we learned from looking at that expatriation document is that the colonists were pointing out what was the answer to the test, what was the cure for Moors to be able to get their sovereign rights back. Because the United States of America knows that they're holding on to the Moors under what's called capitulation. What does capitulation mean? Under war terms, right? Under conquest. And as it relates to international law, under conquest, you cannot hold on to a sovereign by use of force. They understood that. So therefore, they recognized that the Moors were delaying their own justice because the Moors had not came back into statehood. That we did not have what's called competent Moorish governments to govern the affairs of Moors and to deal with consular court. So therefore, in the reading, we have to start looking at discernment to start understanding what is it that the Moors should have been learning for the past 100 years. We should have been understanding that the first principle is sovereignty. And sovereignty means statehood. And that everything you do as a Moor is always authorized by the state. And anything you do outside of the state's law makes you an outlaw. So all this time, the Moors have been sending writs and affidavits thinking they're enforcing their inalienable rights, their unalienable rights. Well, guess what, Moors? That's called your divine right. But as it relates to international law, the law was your own treaty. And your treaty said you needed a state in order for you to be able to utilize your judicial authority. So today we'll keep talking about the solutions for Moors. Moors have to start studying their own treaty rights. Moors have to understand that the answer to the test has been in our hands the whole time. But like they said, if you put in a book, the Moors might not recognize. The Moors don't necessarily read, and those who do read don't truly comprehend. So AMPAC has a charge as a beacon to try to assist Moors in interpreting their own treaties, to understand what is your obligation to yourself and to your nation. And that first obligation was for you to choose to return to the entire submission of the laws of the empire. And that's what AMPAC will continually inform all the Moors to do. At the end of the day, the responsibility is on each and every Moor. All right? So let's go ahead and get into the class. As you can see, we got AMPAC's Constitution up. Keeping in mind that AMPAC has amended our Constitution. We've changed some of the language in there. That's what governments will learn as you continuously know better, you do better, right? Constitutions all around the world are constantly revised. So AMPAC has amended their Constitution. We've addressed some of the themes that we recognize in our Constitution that we need to make more clear of. So Moors, go and take a look at our website. That way you can download the most relevant Constitution that we have. That way Moors who are now taking a look at competent Moorish states can get at least an understanding, a basic understanding of what constitutions will look like for you, all right? So we welcome you to take a look at our public law, all right? As Moors start to come into statehood, each of the territories will need a constitution, each territory. What's a perfect example of that? Well, if you go over and look at Capitulation, i.e. Africa, all 54 of their states, now it's 55 because of South Sudan, so it's 55 states, right? All of those states now have a constitution. They refer to themselves as states. So therefore, Moors in northwest of Mexico, right? and the Empire of Morocco have to do the same thing. We have to follow suit. If anything, the Moors of northwestern Mexico are behind schedule. But the example is the Africans, quote unquote, states, because they're not African states, they're really of Aquibelon, right? They decided to get into statehood because they understood those are the principles of international law. So Moors of northwestern Mexico have to do the same thing. It's not because we think that's what we need to do. That's what our treaties say we have to do. Treaty supreme law of the land, we have to follow the instructions. Okay, so that's what AMPAC's Constitution is all about. That's about the sovereignty of the people. The people is the state, and the state is the people. But everything you do as a people must come through the state. And the Constitution is the emanating document that says you have a state. All right? Okay, let's continue. All right, so we left off talking about the 1906 expatriation, citizenship abroad. This is the House of Representatives talking about this. And they were talking about the status of ipso jure Moorish subjects. And remember in class 46, I kept saying, what ultimately was the responsibility of Moors? What's the ultimate responsibility that Moors had? The ultimate responsibility we had was, how do we determine how to get this subject status off of us? How do we get protege and subject status off of us? Well, the reality is the colonists will never remove it because it wasn't their obligation. The obligation was always on the Moors. Always. Thus the reason why the colonists started pointing out Article 15, right, in this document. Okay? Let's take a look at it. They enclosed it, right? They quoted it. Article 15. Immediately, Moors should start examining this, using forensics. The Moors of the 21st century, especially with their cell phones. We have advanced technology start understanding, looking up every little word of a document, understanding what are the correlations here. Because everything that the colonists do is a correlation to our Moroccan treaties. They can't do anything on planet Earth that's contrary to a Moroccan treaty. Everything they're doing on planet Earth right now is in alignment with the treaties, because the treaties give them their authority to operate in Morocco and from Morocco all around the world. So what they've done is they put the Moors in what's called a naturalization status of person. And when they did that, yes, that violated the bilateral treaties of peace and friendship. However, the colonists all around the world, especially in Europe, were doing the same thing to Moors in Europe and in England. They were running Moors out of governments all over planet Earth. So when you take a look at the Treaty of Madrid, with its 12 signatory powers, the 12 signatory powers were European countries, right? So they're throwing Moors underneath the bus, removing them from government. But they also pointed out the fact that the Moors had every right to make a competent claim back to their land. But they had to do it through states. Why? Because Moors had states way before the colonists. That's what Moors have to understand. Especially when you look at the Treaty of Madrid, Article 7 says what? The Sultan had states. So all states belong to the Sultan. And now that there's no more sultans, listen to me, then who do the states belong to now? Talking about the corporate states. They belong to Moors who have a state as well. So all of the corporate states of the United States, all their so-called 50 states, now what you call interdependent states of Moroccan states. And that's not a new theory. It's always been that way because of the treaties. You go back and look at George Washington. George Washington's letter of 1789 at the end says that the colonies are now under the constant guidance and protection of your majesty. George Washington himself used the word protections. What does that mean? They were proteges. They were subjected to Moroccan law. So you must always understand the United States knows that they are interdependent to Moroccan law. Because they know without the Moroccan treaties, there is no United States of America. They know without the Moroccan treaties, there is no United States. So therefore, their job was to keep us in a shallow grave. That way they could run their mayhem without having the true sovereign telling them what to do. That must be understood. All right? Okay, so in order to get Moors further understanding that we as Moors have delayed our own justice. It can be proven time and time again. All right? So it was proven in 1906, the colonists were talking about it, that the Moors delayed their own justice because they didn't follow the Moroccan Treaty of 1880 or the bilateral treaties, right? We didn't do it because we didn't get back to governments, but they ran us out of governments under capitulation. Okay, so this right here is what you call the 1952 France versus the United States of America, all right? France versus the United States of America. This is page 196. We've gone through this before, but it's good to recap. It's good to be redundant because Moors need to see where we've made our mistakes as a people. But more importantly, what's the solution? We can point out problems every day of the week as Moors, but what is the solution? Well, the solution has always been in our own treaties. But one of the good things is France versus United States of America exposed a lot of good things for Moors to go back and now examine. All right? Moors need to really take the time to read France versus United States of America in its entirety. It tells you a whole lot about how you need to enforce your rights and where we made our mistake. So today we're going to read about the mistakes we made as well as the cure in terms of how we can now correct said problem. Okay? So let's see what the ICJ said. Now keep in mind the ICJ is the principal organ, right, of the United Nations. They are the law enforcement. Think about it. They're referred to as the principal organ of the United Nations. What does that tell you? That the court, the ICJ court, as an organ, is the premier organ of the United Nations. Why is that? Because courts have to maintain the organization. Courts are responsible for maintaining the laws of planet Earth. So therefore, the judges are always referees to deal with disputes. All right? So the principal organ is the ICJ. So let's find out what the principal organ, the ICJ, said about France versus the United States of America as it relates to Moors and as it relates to the jurisdiction that the United States was hoping they could hold on to based upon what they call perpetual capitulation. What does that mean? They want to now say the treaties really couldn't be enforced by Moors, but yet they want to hold on to the treaties, but at the same time say the Moors have a right to enforce the treaties, but the United States wants to enforce the treaties. It doesn't work like that. There's two parties to every contract. But they want to say the Moors were in a shallow grave. They couldn't enforce their side of the contract because they were stateless. So let's learn some more about this, okay? All right, so this is page 196. We're going to scroll down. More should read all of this. I'm just picking a choice subsection of the judgment. Keep in mind, all judgments out of the ICJ are final. It's a final decision that cannot be appealed. Any judgments that come out of the ICJ cannot be appealed. They are final. So therefore, as we're reading this, keep in mind, the United States of America knows they're obligated to this. They can't appeal this, which means they can't appeal anything that a Moorish state government issues from their consular court, as long as that consular court is maintaining the treaties based upon the value and understanding of the treaties. You cannot, how can I say, you cannot infringe on the rights of the United States of America. We must always maintain equality of the treaties. Moors cannot become belligerent themselves. We must always maintain the honor of our treaties because we have an obligation to maintain peace and friendship. All right? That's our obligation. Don't worry about what they've done. We need to focus on what we're supposed to do. All right? Because two wrongs don't make a right. So Moors need to start understanding what the ICJ is saying right here, okay? All right. So, Mother, if I can have you start reading here. Now, keep in mind, before we start reading, why are we reading this? So I can show Moors what the ICJ was saying about your own Moroccan treaties. Listen to what they're saying about the treaties, about your rights, that you've been delaying your own rights. Listen to what they're saying here. Just take the time to really listen. Okay, Mother.
The fourth contention of the United States is that the extensive consular jurisdiction as it existed in Morocco in the year 1880 was recognized and confirmed by the provisions of the Madrid Convention, and that the United States, as a party to that convention, thereby acquired an autonomous right to the exercise of such jurisdiction, independently of the operation of the most favored nation clauses.
Okay, let's stop right there. So what are we learning right off the top? Here's what we're learning. Let's read it real quick. The fourth contention, so keep in mind, if this is the fourth contention, that means the ICJ was talking about contention number 1, 2, and 3 prior to this. So Moore's got to go back and do some research, right? Or do some reading. The fourth contention, so they was given a list, so this is number 4. The fourth contention of the United States is that the extensive consular jurisdiction as it existed in Morocco in the year 1880 was recognized and confirmed by the provisions of the Madrid Convention. Okay? So the United States of America was saying their consular jurisdiction was a legal status. That it was not illegal, it's not invalid, because the Treaty of Madrid, Article 15, paragraph 2, said that the Moors, if they were still naturalized, then the United States of America could hold on to them as property under capitulations without any restrictions. So that's what the United States is pointing out right here. Okay, let's start from top. The fourth contention of the United States is that the extensive consular jurisdiction as it existed in Morocco in the year 1880 was recognized and confirmed, they talked about a treaty, by the provisions of the Madrid Convention, and that the United States as a party to that convention thereby acquire an autonomous right to the exercise of such jurisdiction, independently of the operation of most favored nation clauses. So here's what the United States is saying. That they say their rights came from what? Their rights came from a Moroccan treaty, a Moorish treaty. Look what they're doing. They're using your treaty to say they get to maintain naturalization over you as a Moor. They're using a Moorish treaty to now do what? Hold a Moor captive with his own treaty. What does that tell you? They're telling you that the Moors have delayed their own justice, that the Moors did not exercise the right of paragraph 1 of Article 15 of Treaty Madrid. That the United States said, are pointing out section 2. So you got Article 15, paragraph 1, and paragraph 2. The United States is claiming that paragraph 2 gave them the right to hold on to jurisdiction of Moors because Moors are supposed to exercise their rights to now paragraph 1. You got to see what they're saying. Okay, let's continue.
There can be no doubt that the exercise of consular jurisdiction in Morocco in the year 1880 was general, or that the convention presupposed the existence of such jurisdiction. It dealt with the special position of protégés and contained provisions for the exercise of jurisdiction with regard to them. On the other hand, it is equally clear that there were no provisions of the convention which expressly brought about a confirmation of the then existing system of consular jurisdiction or its establishment as an independent and autonomous right. The purposes and objects of this convention were stated in its preamble in the following words. The necessity of establishing on fixed and uniform basis the exercise of the right of protection in Morocco and of settling certain questions connected therewith. In these circumstances, the court cannot adopt a construction by implication of the provisions of the Madrid Convention, which would go beyond the scope of its declared purposes and objects. Further, this contention would involve radical changes and additions to the provisions of the convention. The court, in its opinion, interpretation of peace treaties, second phase, ICJ reports, 1950, page 229, stated, "It is the duty of the court to interpret the treaties, not to revise them." Okay.
So in this paragraph, what's happening? The United States was trying to get the ICJ to agree that the United States of America had a fixed capitulation over the Moors, meaning that the Moor status was going to be permanent as being Moroccan subjects. And the ICJ is pointing out that it's not the ICJ's job to do what? They say it is the duty of the court to interpret the treaties, not to revise them. The United States of America wanted the ICJ to give them a favorable decision that they got to hold on to the Moors permanently. But the ICJ recognized that Article 15 of the Treaty of Madrid, the first paragraph, said the Moors had a right to consent back to the Moroccan government. Then ultimately it was the decision of the Moroccan government to say whether the Moors could remain naturalized. And it also came down to the self-determination of each Moor who was seeking to return to Morocco. So the ICJ told the United States of America, yeah, we can't just sit here and issue a decree that will be permanent, final, that the Moors don't have rights. It doesn't work like that. Okay? Let's continue.
The fifth contention of the United States is that the consular jurisdiction in Morocco was recognized and confirmed by various provisions of the Act of Algeciras, and that the United States acquired an autonomous right to exercise such jurisdiction independently of the operation of the most favored nation clauses.
Okay, stop right there. So right here it's saying the fifth contention of the United States is that the consular jurisdiction in Morocco was recognized and confirmed by various provisions of the Act of Algeciras, and that the United States acquired an autonomous right to exercise such jurisdiction independently of the operation of the most favored nation clauses. So what are they saying right here? They were talking about Article 102 of the Act of Algeciras, okay? Let's click on that real quick. Okay, here we go. This is the Act of Algeciras, 1906, Article 102. It says what? Every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects by Sharifian jurisdiction. So what's happening? In this article right here, it was the Moors' responsibility to enforce 102. But since the Moors had acquiesced, we're talking about acquiesce today, acquiesced, what does that mean? We were still stateless, we were still prisoners of war, we had made a proper claim under statehood to be a party to enforce said treaty, then automatically this treaty now did what? It now went to the next heir of the contract, which was the United States of America. They ended up being able to enforce 102. On who? More subjects. So the United States of America is saying they get to enforce these laws on more subjects because it's in the treaty. You see how the United States of America is using a Moroccan treaty to their advantage. Moors got to understand, when you're a Moor subject, that means you're naturalized, that means you're a person, artificial person, and you're the property of the United States. Okay? You're a Moor subject. What does that mean? You're stateless. That means that you have not chosen the entire submission of the laws of the empire to return to a competent Moorish state. And until then, you're still a Moorish subject, even though you may have a nationality card. Because your nationality card was not issued by a Moorish state government. It's just a nationality card that's self-proclaimed. It was not issued by a Moorish state government. Okay, let's go back. Okay, so let's pick it up from here.
In 1906, the 12 powers at Algeciras all exercised capitulatory rights and privileges to the extent that they were prescribed either by the General Treaty with Great Britain of 1856 or by the Spanish Treaty of 1861. They did so by virtue of direct treaty grant, as in the case of Great Britain or Spain, or by virtue of the most favored nation clauses, as in the case of the United States, or without treaty rights, but with the consent or acquiescence of Morocco, as in the case of certain other states.
Stop. This is very powerful, what was just read. More got to take the time and look at the forensics, understand the law and history of what you just read. Listen. In 1906, 12 powers at Algeciras all exercised capitulatory rights. So I keep trying to tell more about this capitulatory. What does that mean? All the 12 powers were who? The colonists in Europe, including the United States, right? holding on to the rights of Moors all over planet Earth. It was on the capitulations, and capitulations mean what? Under war, right? Use of force, right? Forced assimilation, right? But they had those rights and privileges to the extent that they were prescribed either by the General Treaty with Great Britain of 1856. 1856. What happened around 1856? Think about the United States of America. What happened around 1856? That was Abraham Lincoln.
Dungy case.
Right? William Dungy. Soon after that, what happened?
Dred Scott.
Dred Scott. Why? Why did that happen? Because the colonial powers were all putting together treaties as it relates to how you deal with Moors. You got to understand this date means something here. Or by the Spanish Treaty of 1861, dealing with Moors, right? All these people they're talking about how do you subjugate Moors on the capitulation. What happened in 1861? Civil War. The southern states wanted to hold on to their slaves, their Moroccan subjects. And they were saying, hey man, there's treaties going on amongst all the Christian nations. These Moors have been ran out of government. We get to do what we want to do with our property. They were trying to hold on to the triple principle. They're talking about their sovereignty and independence of their southern states. They're talking about the integrity of their domains of their southern states. They're talking about their economic liberty without any inequality of their southern states. Because of these treaties that are taking place in 1861 and 1856, you guys see the correlation of dates. What else? They did so by virtue of direct treaty grant. So they were granted capitulation rights, right? They were granted capitulation rights by treaties, such as the Treaty of Madrid, 1880, right? The Christians all signed that to hold on to Moors. But they also knew Moors had a right to make a sovereign claim, but they had to do it through statehood. So they immediately told themselves, let's not let these Moors learn how to read and write, because if they can't read and write, then they'll never be able to enforce a treaty because they can't even read the treaty. And it worked until now. Okay, let's start here. They did so by virtue of direct treaty grant. So on the treaty grant between the Christian nations and them signing a treaty with the Sultan of Morocco in 1880, they started now having permission to hold on to Moors as property. As in the case of Great Britain or Spain, or by virtue of most favored nation clauses, as in the case of the United States, or without treaty rights, but with the consent or acquiescence of Morocco. You see that, Morris? This is the ICJ talking about that the consent or acquiescence of Morocco. So Morocco acquiesced or Morocco consented either through treaties, express treaties, or through acquiescence, because they never said rejection or objection to what the colonists were doing. All right, so let's take a look at the definition of acquiescence. Let's remind ourselves, what does acquiescence mean? Okay, Mother.
1. Accept something reluctantly but without protest. Sarah acquiesced in his decision. Synonyms: permit, consent to, agree to, allow, assent to, give one's consent to, accept, concur with, give one's assent to, give one's blessing to, say yes to, give one's blessing to, say yes to, give the nod to, give one's approval to, comply with, conform to, abide by, respect, stand by, cooperate with, tolerate, brook, give in to, bow to, yield to, submit to, suffer.
Okay. So acquiescence means that we agreed to now have them as a sovereign to oversee our rights. We agreed. Why did we agree? Because on acquiescence, it said under acquiescence, we agreed because we never did what? We never returned to Morocco. We never returned to our Moor states. So since we didn't do that by acquiescence, it means that it was a silent consent that we agreed to it, to their capitulation. Because Article 15 of the Treaty of Madrid paragraph 1 gave us rights to come back, to return. We didn't do it. That's called acquiescence. When you don't do it, that means you're really agreeing to the fact that the United States, as an example, gets to hold on to the jurisdiction in Morocco. Okay, let's look at another definition of acquiescence.
Acquiesce. A. In law, acquiescence occurs when a person knowingly stands by without raising any objection to the infringement of their rights. B. While someone else unknowingly and without malice aforethought acts in a manner inconsistent with their rights. C. As a result of acquiescence, the person whose rights are infringed may lose the ability to make a legal claim against the infringer or may be unable to obtain an injunction against continued infringement. D. The doctrine infers a form of permission that results from silence or passiveness over an extended period of time.
Okay, what are we learning here? Well, Moors will say, well, we didn't acquiesce, we did protest. So look, under law, acquiescence, it says, in law, acquiescence occurs when a person knowingly stands by without raising any objection to the infringement of their rights. So Moors haven't been standing by. Moors been sending written affidavits, haven't we? We've been protesting, haven't we? We've been doing that. So you can't say that we just stood by. So what's this acquiescence really about? Well, you have to keep reading. See, Moors would stop right there and say, well, that ain't acquiescence for us. We've been fighting a good fight, and which is true. But you got to listen to what they continually say. You got to use forensic. Listen. B. While someone else unknowingly and without malice aforethought acts in a manner inconsistent with their rights. Your rights of the treaty said what? You have to choose the entire submission of the laws of the empire. That's your right. Not half your rights, your entire rights. If you don't follow the instructions, guess what you've done? You've acquiesced. Listen. C. As a result of acquiescence, the person whose rights are infringed, so Moore's rights been infringed, may lose the ability to make a legal claim. So Moors haven't been able to make a claim. Why? Because we wouldn't follow the instructions of our rights, our entire rights, which was statehood. So under acquiescence, we didn't have the ability to make a legal claim. What do they say when they say legal claim? That's called a competent claim through statehood. Okay, infringer may lose the ability to make a legal claim against the infringer or may be unable to obtain an injunction against continued infringement. So what's the injunction? You can't stop them because you haven't made a proper claim to your rights. Rights of indigenous people, Article 5 says you got to come back to statehood. It's all about states. The Vienna Convention of 1969, Article 1 says what? Treaties concluded between states. Let's read this last one. The doctrine infers a form of permission that results from silence or passiveness over an extended period of time. See this word passiveness? We're talking acquiescence. Have Moors been passive? Most Moors will say, nah, man, we've been active. We're active Moors. Okay, Moors have to take the time to use forensics. What does active Moors mean versus passive Moors? What does it mean? Listen. Noble Drew Ali said he wanted active Moors and not passive Moors. Noble Drew Ali said what? Active Moors. Active means what? To act. To act. As in the enactment of legislation. You see the act? Enactment. Okay. Act of Algeciras, 1906. Chapter 7, Circle 7. Article 120 says you have to enact legislation. Have Moores done that? Because if the answer is no, guess what? That puts you in a passive position. Listen. Noble Draw said he didn't want no passive Moores. Okay, passive, pass, to pass. P-A-S-S, it means to pass. Okay, listen. To pass means what? To convey from one owner to another. You passed your sovereign authority over to a conqueror. How? Because we haven't made the proper legal claim to our rights of the treaties. So Moores will tell you, man, we've been active. Okay, active starts with A-C-T. And the act of enactment of your treaty say you're supposed to be making legislation. But you can't make legislation unless you have what? A constitution of the state. Well, and the treaty says you needed what? Article 122 of Act Algeciras, Chapter 7, Circle 7. Right? Article 122 says what? You needed what? Constitution laws, ratification depository. So have Moores been active or have we been passive? Because just because you have activity, it doesn't mean you were doing the correct thing. Like I said, according to a triple principle, Moores jumped straight to box 2. He skipped over box 1, and box 1 was what? Sovereignty. Sovereignty means state. So we went to box 2. Yes, we've been active. That's a fact. But is it true? Listen to what I just said. Yes, we've been active. That's a fact. But is it true? No. What makes it true? Upon validity of someone now taking a look at what you have as a state of fact and the facts of your state. Can Moore say they have more states, competent more states on the record, ratified constitutions of each of the territories? That you ratify and deposit that constitution? You've had your 3 branches of government. You have a state flag, not the empire flag, state flag, state seal, public inauguration. Have you deposited that constitution with the Secretariat of the United Nations? Have you ratified, deposited all the treaties and conventions, declarations, and the charter through your state? Have you done that? If the answer is no, guess what that means? You've been passive. Because passive means that you've passed, you conveyed from one owner to another owner. But guess what the United States of America has been doing the whole time? They've been ratifying states. They've been ratifying constitutions of their 50 states. All of their 50 states have constitutions. The United States of America ratifies and deposits treaties, and then they deposit them with the Secretary. They're following the instructions. Have Moores done that? So if the answer is no, then Moores need to put down the Constitution of the United States of America and pick up your own constitutions so that you can stop being passive. You can start being active. Well, hold up. Black's Law Dictionary, 4th edition. Definition of pass. Pass has 2 different definitions. It has pass as an adjective, and it has pass as a noun. Right now, you're looking at the section for adjective, Black's Law Dictionary. We're going to read this first couple sentences, okay? Mother, could you read this for me, please?
Pass. In the language of conveyancing, the term means to move from one person to another, to be transferred or conveyed from one owner to another. As in the phrase, the word heirs will pass the fee.
Thank you. So Moores, in terms of a pass, listen to me, Moores. You go to your treaty, Treaty of Peace and Friendship, 1836. Talks about what? An heir. An heir. An heir. Okay, let's go back to pass. We're using what? Correlations. We're using what? Forensics. We're using discernment right now. This is how Moors have to go about this. Pass mean what? In the language of conveyancing, the term means to move from one person to another. So we pass something to the United States of America to be transferred or conveyed from one owner, Moors were owners, to another owner. Because the Treaty of Peace and Friendship talked about heirs. But this is a bilateral treaty. Who's the other contracting party other than Moors? The United States of America and their citizens. They end up being the heir. Moors passed our sovereign authority over to them under capitulations. Right? Use of force. We gave it up. But then the Sultan turned around and signed a treaty in 1880 and did what? Article 15, paragraph 1 gave us an opportunity to do what? Take it back. With what? A pen. What do we have to do with that pen? We have to do what? We have to do what? Restore the law. AMPAC's Constitution about restoration. The law of restoration, the first law of the triple principle was what? Sovereignty. The law of restoration is what AMPAC is about. Until then, they get to continuously be the heir. Why? Because they're the other party. And according to international law, who are the parties? States. So they're the United States, they're the party, and the Moors can't be an heir until they have what? Restored the states. So in the meantime, we're acting in a status of what? Passive, because we've passed our rights to another owner of the treaty. Let's go down. Mother, can you read the definition of pass? Noun.
Pass, noun. Permission to pass, a license to go or come, a certificate emanating from authority, wherein it is declared that a designated person is permitted to go beyond certain boundaries, which without such authority he could not lawfully pass.
Stop. Noun. Noble Ali said he didn't want no passive more. Why did he tell us that? Listen. Pass, noun. Permission to pass. So we gave them permission to pass. A license to go or come. So when we passed our sovereign authority to them, we gave them permission to start issuing licenses for us to be able to come and go. What else? We gave them a pass because we were passive, because we were not coming back into our treaty rights. We gave them a pass. We passed our sovereign authority over to them, and they immediately started putting together what? Certificates, birth certificates. We passed our sovereign authority over to them, and all of a sudden now, emanating from the authority. What's emanating from the authority? The United States of America is emanating from their authority of their constitutions. Them checking the boxes. Now they're the emanating authority because we passed our authority over to them. Why? Because we failed to check the boxes of the triple principle. Wherein it is declared that a designated person is permitted to go beyond certain boundaries which without such authority he could not lawfully pass or do. Noble Ali tried to tell us don't be passive because we were now giving the colonists authority to still have capitulation over us as Moors. He wanted active Moors. What does active Moors mean? Act. What is an act? Act of what? Enactment of legislation. That's why he wrote a constitution. He was enacting. He was being active, not passive. But he never had an opportunity to ratify and deposit said constitution. Let's just start from the top, okay? All right.
In 1906, the 12 powers at Algeciras all exercised capitulatory rights and privileges to the extent that they were prescribed either by the General Treaty with Great Britain of 1856 or by the Spanish Treaty of 1861. They did so by virtue of direct treaty grant, as in the case of Great Britain or Spain, or by virtue of most favored nation clauses, as in the case of the United States, or without treaty rights, but with the consent or acquiescence of Morocco, as in the case of certain other states. Accordingly, the Act of Algeciras presupposed the existence of the regime of capitulations including the rights of consular jurisdiction, and many of its provisions assigned particular functions to the then existing consular tribunals. Reference has been made in the course of the argument to Articles 19, 23, 14, 25, 29, 45, 59, 80, 81, 87, 91, 101, 102, and 119. For example, Chapter 5, which deals with the customs of the empire and the repression of fraud and smuggling, contains Article 102, which provides, quote, every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects by Sharifian jurisdiction, unquote. In the conditions which existed at the time, this article made it necessary for the prosecution of nationals of the 12 powers for fraud and smuggling to be dealt with in the consular courts.
Stop. Did you see what the ICJ said in this last paragraph? Now, keeping in mind, they pointed out in the Act of Algeciras, listen, right here, this sentence right here, says Articles 19, all the way through, they mentioned through 119, right? All those articles had something to do with consular authority, consular court authority. To do what? To be able to adjudicate any foreigners or Moroccan subjects. So the ICJ is pointing out all the Moors' opportunity to use these articles in enforcing consular court or consular authority, competent consular authority. All right? But here's what you got to look at. In the conditions, this is ICJ talking. In the conditions which existed at the time, this article made it necessary for the prosecution of nationals of the 12 powers. Who are the 12 powers? The Christians. More supposed to be enforcing what? These articles on who? The 12 powers, the Christians. The Moors were supposed to be doing that. For fraud and smuggling to be dealt with in the consular courts. So the ICJ is pointing out all those articles on how to deal with who? The colonists, as well as Moroccan subjects. But the competent Moorish state was supposed to be utilizing its consular courts to adjudicate both foreigners and Moroccan subjects. That's why they're pointing out Article 102. Every confiscation, fine, or penalty must be imposed on foreigners by consular jurisdiction and on Moorish subjects by Sharifian jurisdiction. What should Moors take away from this? We've been delaying our own justice because if we have more state governments, we could have already been now dealing with the execution of consular courts against the foreign powers. This is 1906 when they wrote this. 1952, ICJ is talking about it. Now we're in the year 2022. More have been delaying their own justice. Let's continue.
Since 1937, the position has been one in which 11 of the powers have abandoned their capitulatory privileges.
Stop. It's an important sentence to understand. Since 1937, that's an important date. What happened in 1937? Well, Great Britain relinquished all capitulatory regime. So did Spain. In 1937, all the colonies were no longer claiming any extraterritorial jurisdiction or regimes of capitulation in Morocco. The only one was last to claim it was the United States of America. So let's read this sentence again. Since 1937, the position has been one in which 11 of the powers have abandoned their capitulatory privileges. Just like, remember we went over and I showed you Germany said, yo, I'm out. They said in I think it was 14, they didn't want to have nothing to do with any more Moroccan treaties or jurisdiction. Right? United States of America is the last Christian power claiming a limited and privileged jurisdiction in Morocco. This is ICJ pointing this out. Everybody's out except for the United States of America. Okay, Mo. Start from here again, please.
Since 1937, the position has been one in which 11 of the powers have abandoned their capitulatory privileges and their consular jurisdiction has ceased to exist. Accordingly, Morocco has been able to make laws and to provide for the trial and punishment of offenders who are nationals of these 11 countries. The position of the United States is different and must now be examined.
Stop. So consular court always had the power to adjudicate foreign nationals and more subjects. The United States is the last remaining Christian power in the United States. But now the United States is saying, yeah, we know we're the last, but guess what? What makes us special? This is the United States talking. They have a bilateral treaty with the Moors since 1787. They have a bilateral treaty, whereas the other Christian powers had a multilateral treaty. So the United States of America said, we're special. We have a bilateral treaty. It's one-on-one, right? So now they're going to try to explain why they should be able to hold on to the Moors, because the other Christians never had a bilateral treaty, but the United States of America did. Okay, Mark.
Unlike the Madrid Convention, the Act of Algeciras was general in its scope and was not confined to a limited problem such as that of protection. On the other hand, the interpretation of the provisions of the Act must take into account its purposes, which are set forth in the preamble in the following words. Inspired by the interest attaching itself to the reign of order, peace, and prosperity in Morocco, and recognizing that the attainment thereof can only be effected by means of the introduction of reforms based upon the triple principle of the sovereignty and independence of His Majesty the Sultan, the integrity of his domains, and economic liberty without any inequality.
Okay, so what did the ICJ quote here? This is the preamble of the Act of Algeciras 1906. This is the triple principle itself. So the United States is talking about this. The ICJ is pointing it out. They're trying to use now interpretations to see, does the United States of America have the equal right, according to that bilateral treaty, as well as other treaties, for them to be able to maintain capitulations in Morocco, since the United States of America was claiming that they're the only competent party to the treaty because the Moors no longer have a state. They vacated their seat and their sovereign authority, and they passed their authority onto the other party of the contract. Listen. Okay. All right, page 198.
Neither the articles to which reference has been made above, nor any other provisions of the Act of Algeciras purport to establish consular jurisdiction or to confirm the rights or privileges of the regime of capitulations which were then in existence. The question, therefore, is whether the establishment or confirmation of such jurisdiction or privileges can be based upon the implied intentions of the parties to the Act as indicated by its provisions. An interpretation by implication from the provisions of the Act establishing or confirming consular jurisdiction would involve a transformation of the then existing treaty rights of most of the 12 powers into new and autonomous rights based upon the Act. It would change treaty rights of the powers, some of them terminable at short notice, example those of the United States, which were terminable by 12 months, notice into rights enjoyable for an unlimited period by the powers and incapable of being terminated or modified by Morocco.
Stop. Moors catching what's happening here. The ICJ is recognizing that the United States of America is leaning towards saying that they get to maintain the capitulations. The ICJ said, nah, there's nothing in the treaty that says you get to maintain that, because Article 15 of the Treaty of Madrid, paragraph 1 says Moors can come back and consent. But yes, paragraph 2 of that same Article 15 says that the United States gets to hold on without any restrictions. But that did have one restriction, and what was that? That the Moors always had the sovereign right to make a competent, proper claim. So you know what they say in law, right? Possession is 9/10 of the law. Possession is 9/10 of the law. What does that mean? Your possession is only 90%. You got a 90% possession. You don't have 100%. It's 90%. Well, what does that really mean? See, people that possess something doesn't necessarily mean they own it. Just because it's in your possession don't mean you own it. But you can hold on to it until the proper owner comes to make a claim. So therefore, what they're saying is 9/10 of the law, 90% of its possession, but there's a 10% chance the proper owner will come and make a claim. Only a 10% chance. Until then, you have 90% ownership, but the real owner has 100% ownership. But they got to come and make a proper claim, and what they call possessions 9/10. They're trying to say the Moors only basically have a 10% chance of making a proper claim. But guess what? When Moors do make the proper claim of being competent Moor states, guess what? All our property is returned without interruption. But they knew the Moors were suffering from what? Indoctrination, political indoctrination. They literally put us in a status where we couldn't even read and write. You got to understand what's happening. They just didn't want us to learn how to read and write our own treaties and understand our own rights. That was a political decision they made, right? Okay, so what you got to understand here, let's read it. An interpretation by implication for the provision of the Act establishing or confirming consular jurisdiction would involve a transformation of then existing treaty rights. So the ICJ has recognized the United States of America saying they want the ICJ to kind of twist the words of the treaty, and ICJ's like, nah. Treaty rights are most of the 12 powers into new and autonomous rights based upon the Act. So they wanted the ICJ to try to twist the words. It wasn't working, see? It would change the treaty rights of the powers. Some of them, who are the some? The United States of America, that ain't gonna point it out. Some of them terminable at short notice. What is this? Some of them, what's the sum? Article 25, Treaty of Peace and Friendship, says that any one of the parties can do what? Petition to abandon the treaty. So right here it says, some of them terminable, Article 25 is terminable, at short notice. You see what ICJ is pointing out to Moors? You Moors can, at a short notice, petition to abandon the Treaty of Peace and Friendship. According to the treaty, it's a right, Article 25. The United States want to remove this. They want to hold on to capitulations forever. That's what you call perpetual capitulations or perpetual discrimination. Why would we be discriminating? Because you're discriminating against the rights of the Moors of Article 15 to be able to have the sovereign right to come to return to Morocco. So ICJ said we can't do that. That would violate the treaty. On short notice, for example, now they pointed out, for example, those of the United States which were terminable by 12 months notice into rights enjoyable for an unlimited period. See, the United States of America doesn't like the fact that that treaty expires, terminates every 50 years. It terminates every 50 years. Why is that important to understand? The United States knows that they have to always negotiate for it to be renewed. No different than any tenant staying in an apartment. You got to go down to that leasing office close to the time for it to expire. You got to go down there and walk down there. Hey man, can I renew? How much y'all going to charge me this time for this next year? What's the new rules and regulations? right? The tenant is always subordinate in the contract. The superior is who? The landlord, the property manager. Moors are the landlord. We are the property manager. And what is our property? Their states. Article 7 of the Treaty of Madrid talks about the Sultan has states, because all the United States, so-called corporation states, are the property of Moors, because they're interdependent upon Moors, Moor states. Okay? So right here, unlimited period by the powers and incapable of being terminated or modified by Morocco. Why is this important? Moors got to understand why it's important. You got to listen to me, Moors. The leverage that Moors have on the colonists is that we can terminate that treaty at any time. Got to give a 12-month advance notice. Hey man, 12 months from now, it terminates. Do we have to sit down and negotiate the terms and conditions of that? Yes, but somebody at the very least has to petition to abandon it. See, the United States of America knows that Moors have the sovereign power to do what? Evict them. Moors have the sovereign power under what's called erga omnes principles to say the United States of America is now trespassing in our land if they remain over their state. If they're now told that they have to leave because the treaty has now expired, they have to remove themselves. The United States of America does not like that. They think, well, heck, we won the war. We conquered the Moors. Yeah, you did. But treaty is supreme law of the land. And when Moors wake up and come back in the statehood, guess what? They have to abide by Moroccan law. Guess what? Article 15, paragraph 1, now is enforceable upon them. What am I saying? The United States of America will have to make a decision within the next 14 years or less. Think about it. The treaty expires in the year 2036. It has to be renewed in 2035, 12 months prior. Well, the Moors have 14 years between now, 2022, and the year 2035. That's a lot of time to start negotiating where the Moorish states are going to allow the United States of America to renew that treaty. What does that mean? They know we have the ultimate leverage on them. The clock is on them, not on us. We are already home. They are expatriates of England and Europe. So you have to understand the clock is on them. They know that the Moors can petition to terminate that treaty. So therefore, what does that mean for Moors? Listen to me. Moors don't need to be belligerent towards the United States of America. When we establish our states, we must get into diplomacy. We must talk to them as if we're looking for peace and friendship according to the treaty. Because we got everything to gain and they got everything to lose. So why would we be belligerent towards them? They're already in a position where they will lose if they don't do what? If they don't now choose the entire submission to the laws of the empire. And their obligation is to quit Morocco if they don't want to submit. See how we use Article 15 on them? They got to come back to the entire submission of the laws of the empire as well. So Moroccan subjects got to come back and return to Morocco. And guess who else got to do it? The colonists have to return to Morocco and choose the entire submission of the laws of the empire. Or they have the obligation to quit Morocco. How can they quit Morocco? They themselves can petition to abandon the treaty. But they know if they do that, immediately they're trespassing in someone else's land. They got to go back home. You got to understand what's happening. They want to get rid of this. I'm spending some time on this for a reason. Moors, don't be overly aggressive towards the colonists. You don't need to be. You have the leverage. You have the treaty. They literally put it in their Constitution. Article 6, Section 2, treaty, supreme law of the land. Okay, Article 25 of said treaty, bilateral treaty, says we can evict you and then you'll be trespassing in our land. Don't you understand now why the rights of indigenous people, when you read it, of 2007, says the indigenous people can do what? Demilitarize the land. You think they just made that up? They got that from the Act Algeciras. They also understand the United States of America is on a limited time frame and they can be evicted. So Moors, just calm down. Get back to the triple principle. Be in honor of our ancient mothers and fathers. Exercise what's called your enactment of legislation through your states and consular court. I'm taking my time right here for a reason. The ICJ is pointing out some things for the Moors, but they're also pointing out what? Pain points for the United States of America. So when you start talking about the secret societies, the Shriners, this is what they don't want you to know. This is the secret. This is your Illuminati. This ain't Illuminati. What does Illuminati mean? Light. ICJ is spreading light, shedding light. It's a beacon on Moors' rights. That's the secret. Hide the Moors' sovereign rights. Let's continue. Right here.
Neither the preparatory work nor the preamble gives the least indication of any such intention. The court finds itself unable to imply so fundamental a change in the character of the then existing treaty rights as would be involved in the acceptance of this contention. There is, however, another aspect of this problem arising out of the particular articles to which reference has been made above. These are the articles which include provisions necessarily involving the exercise of consular jurisdiction. In this case, there is a clear indication of the intention of the parties to the effect that certain matters are to be dealt with by the consular tribunals, and to this extent, it is possible to interpret the provisions of the Act as establishing or confirming the exercise of consular jurisdiction for these limited purposes. The maintenance of consular jurisdictions is so far as it may be necessary to give effect to these specific provisions can, therefore, be justified as based upon the necessary intendment of the provisions of the Act.
Stop. This is very important to understand, Moors. ICJ right here is admitting, since the Moors were not exercising their sovereign rights of Moorish states, which means if they didn't have a Moorish state, they didn't have a consular court. And the ICJ is pointing out it's necessary to have courts to govern the affairs of people and states. And since the Moors were not exercising their sovereign rights, they were stateless, then unfortunately, the United States of America ended up with what's called a limited consular jurisdiction. Listen. There are the articles which include provisions necessarily involving the exercise of consular jurisdiction. In this case, there is a clear indication of the intention of the parties to the effect that certain matters are to be dealt with by consular tribunals. So the ICJ said, we got to make sure there's some type of court going on. That's their obligation. They're reading the treaty. It must be a consular court. That's the supreme law of the land. Listen, consular tribunals, and to this extent, it is possible to interpret the provisions of the Act as establishing or confirming the exercise of consular jurisdiction for these limited purposes. So they're agreeing with the United States of America. The United States could utilize consular court on a limited purposes only because the Moors were not exercising consular court. They ended up being the heir to the treaty because they were states. We were supposed to be governing them. They ended up governing us. And the ICJ recognized because of the treaty, they had a right to govern us under capitulations because Moors were supposed to come back to Article 15, paragraph 1. And until then, the ICJ recognized there had to be some law and order. But what the United States of America has is limited. That's very important for Moors to understand. It's limited. ICJ, this is a report from ICJ. This is final. So in other words, the United States of America has what? Possession is what? 9/10 of the law. So they possess a limited purpose of civil and criminal jurisdiction over Moroccan subjects and Moroccan proteges. The maintenance of consular jurisdiction insofar as it may be necessary to give effect to these specific provisions can therefore be justified as based upon the necessary intenement of the provisions of the Act. So the ICJ saying, man, courts are necessary. We don't really want to throw the Moors underneath the bus, but the Moors have done this to themselves. The Moors have delayed their own justice. They have infringed upon their own right of claim. And until then, until they finally check the boxes and come back into statehood, then unfortunately, the United States of America gets to hold on to a limited purpose of their civil and criminal jurisdiction, in which they call subject matter jurisdiction and territorial jurisdiction. Listen to me, Moors. Every time the Moors step into a colonial court, the first thing that magistrate says to you is, this state has what? Subject matter jurisdiction. They have subject matter jurisdiction. Well, who are the subjects? Moroccans. So they got subject matter jurisdiction over who? The subjects of Morocco. You need to listen to what they say in those tribunals. Listen to those words. They have subject matter jurisdiction and territorial jurisdiction, and their territorial jurisdiction comes from capitulation. And what does capitulation mean? That means under military law, for use of force, they're holding on to us. However, the Moors should have been taught that if they came back into statehood, had their three branches of government, state flag, state seal, oath of allegiance to said state, ratification depository, we could have fixed this problem a long time ago. But until then, the United States of America used to hold on to a limited civil and criminal jurisdiction. And what's giving them permission to do it? Listen to me, Moors. What is the ICJ pointing out that gives the United States of America permission to do it? Listen, what do they say it was? Provisions of what? The Act. What Act? That gave the United States of America permission to have civil and criminal jurisdiction over Moors. Your own Moroccan treaty is putting you in jail. Your own Moroccan treaty, they're using it to have authority over you. Of your own laws is putting you in jail, Moors. Your own laws is putting you in jail. That's what they're using the Act of Algeciras to put Moors in jail. They're using the Act to hold on to civil and criminal jurisdiction over Moors. They're using your own Moroccan treaties to put you in bondage. All because what? Moors have not learned what sovereignty means. For some reason, we think a nationality card is a silver bullet that fixes all the problems. No, that was the first start to say that you have awakened. As soon as you wake up, first thing you got to do now is choose entire submission of the laws of the empire. And when we don't do that, we are still in a status of called passive. And passive means you're stateless because you haven't been active, because active means enactment of legislation. Why don't our Moorish teachers just simply tell us this? More importantly, let's just start doing it. Moors need to understand these are the instructions. Let's continue. Okay, Mo.
This result is confirmed by the provisions of Articles 10 and 16 of the Convention between Great Britain and France of July 29, 1937. These articles refer to the jurisdictional privileges accorded on the basis of existing treaties or enjoyed by the United States of America under treaties at present in force.
Stop. The United States of America is enjoying what? They literally use the word enjoy. The ICJ said the United States of America is enjoying privileges under what? Treaty rights. What treaties? Moroccan treaties. These articles refer to the jurisdiction privileges accorded on the basis of existing treaties or enjoyed by the United States of America under treaties at present in force. What present in force treaties? Bilateral Treaty of Peace and Friendship, Multilateral Treaty of Madrid, Multilateral Treaty of Algeciras. All Moroccan treaties. Moroccan law is what they're using to imprison Moors. Let's continue.
I'm sorry. They presuppose, therefore, that the jurisdictional privileges of the United States, even after the surrender of British capitulatory rights, would not be limited to the jurisdiction provided by Articles 20 and 21 of the treaty with Morocco in 1836. This view is also supported by the provisions of Article 4 of the Protocol of Signature to this convention. This article provided for the abrogation of certain provisions of the General Treaty of 1856, and as regards the Act of Algeciras, for the renunciation of the right to rely upon Articles 1 to 50, 54 to 65, 70 and 71, all provisions of Article 72, after the word permit, 26, 75, 76, 80, 97, 102 to up until 119. And it also provided that in Article 8, is that, what is it? 81?
Yes.
By the competent consular authority must be deemed to be omitted, and in Article 91, the word competent must henceforth be substituted for the word consular. It is clear that in 1937, France, representing Morocco, and Great Britain were proceeding upon the assumption that certain of the provisions of the Act of Algeciras recognize a limited consular jurisdiction for the purposes of the judicial proceedings therein described. The court is not called upon to examine the particular articles of the Act of Algeciras which are involved. It considers it sufficient.
So, start right there. Here's what Morris needs to understand. You see this word, Morris? Competent consular authority. Competent is the key word. Morris just can't be self-appointed and say, I'm this title and I'm that title, because you're not the competent consular authority. What makes you the competent consular authority? Your Constitution sets forth the officers, and those officers are elected by the people of that Constitution. The people allow you to have that privileged status of that officer of the state. So you become competent because first you have a Constitution, and you ratify and deposit, you follow the instructions. You've taken your oath and allegiance, right? A judge has signed off on that, making you now the authority. So Moors got to understand, this word competent means a lot. If any Moors have read this, they know that the ICJ threw out France's consular court, because they say France's consular court was what? Incompetent. It was compromised. They threw it out. It was incompetent. This word competent is one of the most important words you will read as it relates to government officials. The Vienna Convention of 1969 was a law of treaties. Article 2 talks about the competent authority. Comes from the emanating document. Moors got to understand this word competent means a lot. I'm taking my time on this. Competent. Moors can't be self-appointed. Because you self-appointed, that means what? You're acting in a status of passive. You're not active. You think you're active. You're acting in a status of passive because you don't realize what you're doing is you're still passing the authority to the colonists because you're delaying your own justice, because you're not acting as a competent authority. You're acting as incompetent according to the treaties, not because AMPAC says it. It's because the treaties say you must be competent through a constitution in order for you to have the sovereign authority to be the competent consular authority. That's what your treaty says. Backed up by the charter and its declarations that now tell you specifically who the competent authority is. Comes from the emanating document of the Constitution of your Moorish state. Okay, right.
It is clear that in 1937, France, representing Morocco and Great Britain, were proceeding upon the assumption that certain other provisions of the Act of Algeciras recognize a limited consular jurisdiction for the purposes of the judicial proceedings therein described.
Okay, stop. So once again, the ICJ is pointing out what? That there's limited consular jurisdictions. Why is it limited that the foreigners get to have limited? Why? Because they're foreigners. Only indigenous people get to have full powers because they're indigenous. They don't have a treaty that has an expiration date. They're already home. Everybody else is visiting for 50 years at a time. So their status is limited. The foreigner status is a limited consular jurisdiction. For what purpose? For the purpose of judicial proceedings. Therein described. So the Moors keep telling other Moors, yeah, man, you in a jurisdiction. That's why they get to use civil and criminal against you. So you got to get out that jurisdiction. That's 100% correct, Moors. But when you get out of that jurisdiction, listen to me, Moors. When Moors, so-called, get out of the jurisdiction in the United States of America, because they think they got what? They got a nationality card. They say, yeah, man, you ain't in a jurisdiction no more because you got a nationality card. I'm being serious right now. You think because you sent some written affidavits to the colonists telling them, hey, man, I got a nationality card. I know who I am. So that gave me back all my rights. It did not. Nationality card, exactly what it is. Nationality card, but it's not a national identification card from your state government. This is what you call a self-determined private law document. It's private. It's not public from a state government. So Moors are still in the jurisdiction of the United States of America, even though they have a nationality card. The treaty is specific. It said come back, do what? Choose the entire submission of the laws. This is not entire. This is taking shortcuts. This is not authorized by who? The competent authority. I get it. We need a nationality card. But now you're supposed to now take this to your Moroccan state and say, yeah, man, I want to turn this in. And now get a what? Official state identification that says you're a national of your state. Until then, the United States of America gets to do what? Has a limited consular jurisdiction for the purposes of the judicial proceedings, both civil and criminal, over who? Moroccan subjects who have a nationality card. Let's continue. The court.
The court is not called upon to examine the particular articles of the Act of Algeciras which are involved. It considers it sufficient to state as its opinion that the consular jurisdiction of the United States continues to exist to the extent that may be necessary to render effective those provisions of the Act of Algeciras which depend on the existence of consular jurisdiction.
See what happened? The ICJ said, there's got to be a court. And by default, they get to hold on to the limited jurisdiction over Moors. Continue.
This interpretation of the act in some instances leads to results which may not appear to be entirely satisfactory.
Stop. You see what the ICJ just said? They just had a moment of empathy. That one sentence is an empathy statement. This interpretation of the act, in some instances, leads to results that which may not appear to be entirely satisfactory. See, they already knew the Moors had some rights, but they were not at the ICJ in 1952 to defend their rights as a state, because only parties in a suit to now be at the ICJ must be states. They knew in 1952 the Moors were in the United States of America already writing writs and affidavits even in 1952, because C.M. Bay, Charles Moseley Bay, wrote a constitution called the Zodiac Constitution in 1949. So they knew the Moors were trying to get their rights back, but no one was telling the Moors the instructions of the triple principle. But even C.M. Bay was cognizant enough to know it started with a constitution. He just didn't know what boxes he needed to check next. Let me ask the Moors a question. You keep saying this Constitution, United States of America, is your Constitution. Then why did Noble Ali write a Constitution if this is your Constitution? Why does C.M. Bay write a Constitution if this is your Constitution? Moors not even paying attention to the leaders that was at least trying to get us back into sovereignty. I'm going to read it again. This interpretation, what interpretation? They're saying the interpretation that the ICJ said, man, unfortunately, we got to let these colonists hold on to the jurisdiction of the Moors because the Moors failed to come back into sovereignty of their own triple principle. So it is what? This interpretation of the act in some instances leads to results which may not appear to be entirely satisfactory. Because they already told you prior to this what? They listed all those articles that show how Moors had jurisdiction over what? Who? Foreign powers. So they knew what the power Moors got. And they know it's unsatisfactory. It's unsatisfactory that Moors have failed to check their own boxes. The Moors have delayed their own justice. Let's continue. But
that is an unavoidable consequence of the manner in which the Algeciras Conference dealt with the question of consular jurisdiction.
Stop. ICJ said what? But that is an unavoidable consequence that the colonists get to maintain a limited jurisdiction because contracts are like manner. Both sides can enforce it. And if the other party fails to show up, guess what? Verdict for the plaintiff. Failure to appear ends up in verdict for the plaintiff. So what? So what happened? It ended up being an unavoidable consequence. The Moors didn't show up. Verdict for the plaintiff. Who's the plaintiff? United States of America. They won jurisdiction, both civil and criminal, over Moors. And Moors keep saying, yeah, man, United States of America don't have jurisdiction over me because I got a nationality card. Not realizing, or should I say, unknowingly, not realizing they were violating their own Moroccan treaties because the first box of the triple principle was sovereignty and independence of a state, not a nationality card. What was the second mistake we started making? We honestly think this Constitution, United States of America, is ours, and it's not. If it was ours, Noble Ali wouldn't have been writing a constitution. What's the third problem? We think state statutes is how we enforce laws on the colonists. What's the fourth problem? Unfortunately, We haven't been reading the treaties to understand who are the contracting parties of a contract. And it is not a Moorish American. It is simply just a Moor, a Moroccan, who happens to be Moorish in Morocco. That's it. Let me give you an example. Let's say you got an account at the credit union. You've been going there for 5 years. You know everybody in there and everybody knows you. You know the manager on down to the newest employee. You walk in there all the time, once a week. Sometimes you leave the house, you say, man, I left my ID. I got to go back to the house and get it. Why? Because you know when you walk in there, if you want to do a withdrawal, what are they going to ask you for? ID. Okay, you got ID. Why are they asking for ID? Because that's a part of the contract. They must ask for it no matter what, even though they know you. Okay, your bank account says what? For example, it says Kendrick Johnson. You pull out of pocket your nationality card, Kendrick Bay. They look at the card, they look at you, they say, you got some other ID, because that's not the name on the account. They've been looking at you every day, every week. They know exactly who you are. But as soon as you gave them some identification that says something contrary to what's on the contract, listen to me. Is Kendrick Johnson on the contract or Kendrick Bay? It's Kendrick Johnson. So the bank is enforcing the name of Kendrick Johnson. That's the only way to enforce said contract is the name that's on the contract. So if you provide identification that's on the name of the contract, you get access. So what have Moors been doing? So when you say you're a Moorish American, okay, where is that in the treaty? It don't exist. Which means what? You can't get access. You can't enforce something, and you can't make somebody do something unless you have the identification that says you can enforce it. And that identification must say Moor, Moroccan, Moorish. But you can't add a prefix or suffix to that. Moors have done what? We've added what? A suffix to the word Moor called American. And we're telling people in a minute, we're not African American, but we turn around and say we're Moorish American. We're not Moorish American. Listen to me. If the Moors decide at some point within the next 14 years to petition to abandon the treaty, guess what happens to the United States of America? It no longer exists. Because the United States of America is a party to the contract. If the contract is now terminated, it becomes null and void, then the United States of America no longer exists as a party. The so-called Americans don't exist no more because they only exist according to the contract. Once the contract is now terminated, Americans no longer exist because it's just a political jurisdiction of a contract. Because there ain't no such thing as Americans. There's Germans, there's Russians, Polish, there's people from Scotland, there's British, Italians, Scandinavians. Ain't no such thing as Americans. It's a political jurisdiction according to a contract. But there are Moors. We've always been Moors. We'll always be Moors. And the word Moor is in the contract. There's no Moorish Americans in history on any contracts. So if the United States of America goes away, and the word America goes away, but you've been calling yourself American, does that mean you go away as well? Because you called yourself the American, does that mean your status dissolves as well and goes away? Because you have now branded yourself as American. Do you go away as well? Do you get expelled because you're saying you're American? You're saying you're the American, right? American is the other side of the contract. Do you go away? No. But that's what you're saying when you keep calling yourself the American. You're saying you're the other part of that contract. You're the other party. Or you're creating a third-party interloper calling yourself Moorish American, and that is not a party to the contract. Why am I spending time on this? Because you got to understand what they're talking about on here. They're talking about contracts. How to enforce contracts and the parties must be known. And they're saying the party was not there to make a proper claim. And then when Moors, now that they're awake, you're going to try to make a claim as Moorish American, and that's not in the treaty? How are you going to make that claim? I'm being very serious with the Moors right now. I love all the Moors. We got to fix this. We got to course correct. We got an opportunity to do that. But we cannot do that under nom de guerre, a misnomer, a brand that we've given ourselves and it don't exist in the treaties. And the ICJ knows this. The United Nations knows this. They know you're not Moorish Americans. And so should you. Okay, as we start to close, we'll pick up the rest of this reading in the next class. Why are we studying this? We need to understand what we've done wrong and what we need to do right. There's no use in pointing out problems without understanding solutions. The ICJ has already told you that Moors acquiesced. Noble Drew Ali said, don't be passive. But what have we done as Moors up until the year 2022 thus far? We've been passive. We have not been following instructions very well. We've got written instructions in treaties. We've got written instructions in charters. We got written instructions from Noble Drew Ali. We got all kinds of instructions. We're not following them. And the ICJ is pointing this out, that it's unfortunate. It's unfortunate. It's what? It's an unavoidable consequence because Moors have been delaying their own justice. So as we start to close out, like I said, we'll finish this up in class 48. What's happening? We've heard about this word acquiescence, right? We looked up the word. Listen. This is 1952, France versus United States of America, what we're going over right now. We'll keep talking about this, a couple more pages. So far, the ICJ determined that the ipso jure Moorish subjects and the Moorish governments acquiesced to the regime of capitulations. The native Moors' passive consent has caused an unsatisfactory status of allowing the colonists the limited legal authority to govern the civil and criminal jurisdiction of stateless Moors. Whereas Moors have failed to adhere to their own treaty rights, the United States shall enjoy a limited jurisdiction because Moors have delayed their own justice. I'm proving to you, Moors, they've been given a legal, limited jurisdiction of civil and criminal rights over Moors until Moors come back into statehood. I end with that. Islam.